Okay, now this video is going to be real short. What we're looking at here is an Office of the Public Defender. This came from Caitlin Gossett from concerning motion of discovery. This was actually filed January 24th, 2011. Now that's very important, bear in mind, because here we go looking at the verdict order. And that was for the supposed stalking charges. And then here we come in looking at the verdict order from the original case. Now, the original case, they try to claim that I tried to rape this girl, give her pills and everything else. But what it comes down to is I was only originally charged with stalking her and contributing to the delinquency of a minor. The stalking charge was dismissed in court outright. And then the delinquency charge, as you see right here on the appeal, 2 counts of the contributing to the delinquency of a minor, 1 count of battery on a police officer when I beat the shit out of Trooper Duckworth. And what we have is that 1 count of contributing to the delinquency of a minor was found. The other one, I was found not guilty. Now that's very important because this goes to show that there's already an indiscrepancy in the previous warrant bringing up the previous charges, which in fact are trying to bring up things that never occurred, that I was never charged with. And then here in this warrant, I was never found guilty of contributing to Ashley's delinquency because it was appealed after she said that she was coerced by her mother, Trooper Duckworth, and the prosecutor, namely Clarissa Kennard. And again, this was all signed by Judge Hutchison. Now this becomes very interesting here because what we come into is this other little factor. Now here's this right here, which is the order to bring this case, take it from Judge Burnside and bring it before Judge Hutchison. Now, for those of you who don't know, this case was originally set before Judge Hutchison until I filed a judicial ethics complaint against him. We're going to get into that in a moment. Right here is the county clerk's number where this was faxed to my lawyer from the county clerk's office, the stamp from the county clerk's office, showing that we got it from the clerk's office, and it was not sent to us by Assistant Prosecutor Pat Lamb. Now, this is an important thing to remember because here's what we're going to get into. Now, we're going to come back to this later. But here's what we get into, which is very interesting. Here's the statement, the 8-page statement I wrote to the West Virginia State Police. I made 3 copies of this. This is 1 of 3. You can see right here. And this right here is the original statements, 1 of 3. This is a copy for me. This was my copy. I gave a copy to the prosecutor, another copy to the judge, and we kept a copy just so we could put this on record because it's supposed to be put on record at the time that I went for my initial appearance, but they decided not to do that. So here's what we have. Now, there's a mention up here of my uncle, the fact that he was stated by his own children to have a CD possessing child pornography, which is very interesting, considering that I caught him downloading child pornography onto my phone, or sorry, onto my laptop. Then we have over here that he involved himself in a previous lawsuit against my landlord, Julian Chipley, which I won, by the way. But we have multiple little things mentioned on here, including the mention of his cop buddies, going back to the original statement, which we'll get into as well. But here becomes a very interesting, very pointed fact. Okay, I turned myself in at the request of my bondsman on April 19th. Here it is mentioned, April 19th. Jennifer Strock from Princeton. I was in Princeton at the time when I was called. And here's where it gets very interesting because I keep mentioning this whole issue with troopers and fabrication of evidence, and then there's this mention right on down, right over here, even though I misspelled it, of Judge Hutchison. Now, why is that important? Because what we're talking about right here is that it was a conflict of interest for them to even put the case in front of Hutchison. That by putting the case in front of Hutchison, the prosecutor's office, the clerk's office, whoever did the filing, was in violation of American Bar Standard 3-1.3, conflicts of interest. Subsection A, a prosecutor should avoid a conflict of interest with respect to his or her duties. Now, that became a second strike for Pat Lamb by filing this motion. Furthermore, And just as equally as important, hold on, I have to turn my little page of notes here for that whole thing. What we come into here is also the fact that we're talking about West Virginia Rules of Court, particularly Rule 47, motions. An application to the court for an order shall be by motion, a motion other than one made during a trial or hearing shall be made in writing, unless the court permits it to be made orally. It shall state the grounds upon which it is made and shall be set forth the relief and order sought. It may be supported by affidavit. Now, this right here mentions no cause to have it transferred from Judge Burnside to Judge Hudson. So, in fact, Pat Lamb is actually in violation of West Virginia Rules of Court right there. Furthermore, there's the Rule of Court 49, in which it says service and filing of papers, subsection A, service when required, written motions other than those which are heard ex parte, written notices, designations of record on appeal, and similar papers shall be served upon each of the parties. So no such written copy of this was given to me or my lawyer. We had to get this from none other than the clerk's office. Now this becomes an interesting situation here because this is also a violation of the American Bar Association Standards 3-1.2, the function of the prosecutor, paragraph C. The duty of the prosecutor is to seek justice and not merely conviction, as well as Standard 3-1.2 and Standard 3-1.3 concerning conflicts of interest. Now, I'm sorry, I already read the 3-1.2, but what we come into in the 3-1.3 is conflict of interest. Subsection A, a prosecutor shall avoid a conflict of interest with respect to his or her duties. And under that same rule by the West Virginia Bar Association, paragraph F, a prosecutor shall not permit his or her interest with respect. Shall not permit his or her professional judgment or obligations to be affected by his or her own political, financial, business, or personal interests. So trying to get a conviction off of me without actually, I don't know, having something to do here, actually going so far as to have a person accused of a criminal conspiracy put over top of this case, a person I accuse of covering up for the fabrication of evidence in the first case, and the fact that Ashley Redden was coerced by her mother, the prosecutor's office, and Trooper Duckworth, and therefore protecting that would be a conflict of interest to put back in front of Hudson. Yet here we have Pat Lamp doing so. Now we also have the issue that we're looking at the standard of duty. This is the American Bar Association Standard 3-1.5, duty to respond to misconduct, subsection A, where a prosecutor knows that another person associated with the prosecutor's office is engaged in actions, intends to act, or refuses to act in a manner that is a violation of legal obligation to the prosecutor's office concerning such matters. This very well could be considered it, as well as coercing a witness, namely Ashley Redden, to give false testimony. That seems to be an interesting thing. So therefore, he is going to try to protect the prosecutor's office, specifically Clarissa Coonrod. It brings to an interesting little thought here. Because here they are doing something illegal. And the fact that I've already taken this to none other than Kristen Keller shows an interesting little thought in and of itself. And then finally we get down to this. As far as the child porn case goes, there is a mention of the cop buddies right here. My uncle is currently in investigation for, there's a whole issue here with stealing someone else's computer. My mom's ex-boyfriend, who she had information on his computer, as regarding the case and background info and everything else. Filing of false motions with domestic violence petition, And then here's the mention of the Android phone, which I said my BlackBerry was actually mentioned as an Android. Now here we have this, and the information concerning my uncle and his cop buddy, specifically Officer Jason Redden, who is blood related to Ashley Redden. And of course, Karen Carlock on that same phone recording mentioning her buddy Greg with the West Virginia State Police. Now the only Greg I know of is Greg Duckworth. That's right, the same asshole who set me up and that I beat the shit out of. And then here is this thing simply mentioned right here, filed on March 10th, 2011, in the Raleigh County Public Library by none other than Paula H. Deal. And what we have here is a mention of various deprivations of rights, criminal codes, and everything else. So what we have is that instead of charging my uncle with a crime, my uncle was protected by Jason Redden, who used to date my cousin, Jacqueline Keller, and yet having this mentioned and caught on tape of my uncle admitting to being friends with Jason Redden creates a conflict of interest and would expose the reason why he maybe had claims of possessing child pornography, and yet all this was swept under the rug. Now, here's the interesting thing to ask yourself. Why is it that the prosecutor, in light of all this information, even the very accusation that Judge Hutchison was involved in this, that Judge Hutchison was previously protecting an assistant prosecutor and Trooper Duckworth for coercing a witness who was a minor, bringing up false charges and everything else? Why is it they would even have this put in front of Hutchison unless they were seeking none other than to, I don't know, stack the deck in their favor because the evidence they have will not hold up in the court of law at all?